How about the boys? Are they got it locked down?
Good morning, everyone. I want to thank you for coming out today to listen to Lauren Goldberg from KP Law to give us some helpful hints on our meeting agendas and how to run a meeting and conflict of interest. If you have any questions, we ask that you just raise your hand and ask as we're going through the materials, and she'll be more than happy to speak with you individually afterwards as well. Thank you for coming.
Well, thank you everyone for being here. This is eye-opening stuff for first thing in the morning. So I appreciate you showing up and trying not to frown at me from the audience. As Maureen said, my name is Lauren Goldberg and I'm the managing attorney at KP Law, which is town council in the town, as you probably already know. I've been doing open meeting, public records, and conflict of interest law as long as I've been practicing law, which is since 1996, a long time ago. And you think, oh, you couldn't be practicing for that long. I know. Yeah, so I first did that for the state, and then I came to KP Law in the year 2000. I've been working for cities and towns since then. I know, well, first of all, just so that I know, how many of you are on boards or committees? Okay, and how many are staff? Heck of a lot more. All right, so what I'm going to try to do then is just talk a little bit about how to prepare an agenda and stuff like that when we're going through, but please just raise your hand because if you have a question, probably other people do too. And I am going to try to cover what it is that you want to hear about. Okay, disclaimer, because I'm a lawyer and I have to do that. See, I'm going to make jokes and you can help me by smiling, okay? Even if you don't think they're that funny, I do this to my husband all the time. I'm like, that is a dad joke, but I smiled. So we can practice. Okay, today we're going to talk about the open meeting law and the conflict of interest law. By the way, we're going to make this PowerPoint available after the fact. So if you can't read some of the text, which I know you can't because I can't, you'll have the ability to look at it later. Okay, so the open meeting law and the conflict of interest law are part of the so-called sunshine laws. And those laws are intended to make sure that the public's business is done in the public and for the public. Under the open meeting law, essentially, you are supposed to be having boards and committees that are policymakers do their deliberations in the public. So to eliminate some of the secrecy, we want to make sure that for public records purposes, that anything that you are creating in writing, regardless of the form, is available to the public upon request. And then the final piece of this is that the law expects you, the conflict of interest law, to be loyal to the town over any of your own personal interests. That's known, those laws together are known as the three-legged stool of municipal law. If you've got that, you know where to go. So we're going to start with the open meeting law. And frequently we get questions, well, what is a meeting and what type of notice do we have to have? And how does a law apply to email and social media? So we're going to talk about all of those things. The open meeting law really does four things. It requires that there be notice of public meetings. It requires that meetings be held in open session, except in very, very limited circumstances. It essentially gives a framework for how meetings are going to be held by empowering the chair to make all of the decisions about who's going to speak and when and for how long. And the last thing is that it requires that minutes be created so that someone who wasn't at the meeting has enough information after the fact to know what actually happened at the meeting. We'll talk about each of them a little bit more. So what is a meeting? A meeting is occurs whenever a quorum of the board either is present or is talking about something within the board's jurisdiction. So a formal meeting occurs when you post a meeting and then everybody goes to the meeting and there's a majority of the board members. A meeting that happens that's essentially a violation of the law happens when there is a serial conversation between board members, or when there is something like an email that goes to all board members, sharing feelings, ideas, beliefs, and concerns of the board members. So a meeting can happen by accident. It can happen inadvertently. And in theory, it could happen intentionally if it was not posted and there's a decision to talk about something outside of an open posted meeting. That is typically not the case. That is not typically what happens. Instead, it's really kind of an accidental thing. I think also a misunderstanding of the risks of email. And so we're going to talk about that as well. Okay, so subcommittees are another area where there are a lot of open meeting law violations. So what is a subcommittee? And a subcommittee is essentially a group that is directed or requested by the appointing body to undertake a particular task and to do it together. So for example, if a single individual, let's say you're at a meeting and the chair says to a member of the board, you know, can you go look into that and come back and tell us about it? That's not a subcommittee. It's a single individual. But if what the chair said is the two of you, could you please go and together look into that thing, make some, you know, analyze the issues and then come back and report to us. Now that is going to be a subcommittee for purposes of the open meeting law because they're more than one person and they're being authorized to act collectively. Okay. So I think one of the easy ways to think about this is perhaps the finance committee. The finance committee might have liaisons to different boards and committees. If they are by themselves and they are responsible for being the liaison, they go to the board or committee meeting, the other board or committee meeting, and then they come back and they report to the FinCom. This is what happened at that meeting, da, da, da. Okay, no subcommittee. It's a single member of the finance committee. Similarly, if that single member of the finance committee goes to the other board's meeting, but another member of the finance committee sits in the audience, they haven't been authorized to act collectively. They're not a subcommittee, even though there's the two of them present. Compare that to the finance committee chair saying, you two go to that meeting, analyze what happens there, and bring it back to us with a recommendation. Now, those two have been authorized to act collectively, and they're a subcommittee for purposes of the open meeting law. If you think, wow, that's really splitting hairs. Yes, it is, but that's how the law works. So how do you avoid making, an error with respect to a subcommittee? Only authorize one person to go and do something. That's the easiest way. The other way that there can be a subcommittee, of course, is let's say the board says we would like this group of people, two of our members and 3 other people to come back with a recommendation on whatever it is, bike trails, let's say, the recreation committee. That bike trail subcommittee is also subject to the open meeting law, just like those 2 members who were authorized to act collectively, even though there's less than a quorum of the finance committee members or the recreation committee members that are appointed to that other committee. The point is that a subcommittee has to post and it has to follow all of the requirements of the open meeting law, including taking minutes of its meetings and meeting in, for example, a public place or a place that's open to the public and compliant with the ADA. So there is one way, or one example that is exempt from this subcommittee rule, and that is when a single individual has a statutory or charter given authority to carry out a task by themselves. So the example, and this is a case, is that the superintendent under state law has sole authority to make appointments of principals. And in this case, the superintendent appointed a committee to advise him, he was a man, to make these appointments. And that committee was not subject to the open meeting law. He, as an individual, was not subject to the open meeting law. And so the committee that he appointed, when he had sole authority to be the decision maker, was also not subject to the open meeting law. But the takeaway is all other subcommittees are. There's kind of another thing out there that that or the other part of the test, which is the committee a part of government? And a perfect example of that is, sometimes a board or committee might want to get feedback from individuals, and they might say, we're gonna have, one of our members show up every Wednesday, and, at lunchtime, if you have issues, you can come on in and talk about it. And we're encouraging people to come. That's not a committee. That's not a part of government. It's essentially crowdsourcing. And so that wouldn't be subject to the open meeting law either. Does anybody have questions about subcommittees? Okay. All right. So there are certain activities that are not subject to the open meeting law, provided that a deliberation does not occur. One of those activities is a site visit. And a site visit is something for which you cannot post a meeting. Does anybody have any idea why? You can't invite people onto private property against their will, and the private property is most likely not ADA compliant. So going for a site visit is not a meeting. It doesn't have to be posted under the open meeting law. But importantly, you cannot have a deliberation on that site visit. And what's the deliberation? Essentially talking about anything within the board's jurisdiction. So we'll use the Conservation Commission as an example. Let's say all of the members go to the site visit and they're, looking around, and someone says, take note of that pile of sticks. That is not a deliberation. Okay. We all see it. It's a pile of sticks, but it is a deliberation to say, see that pile of sticks? I think it's within the buffer zone, and it's definitely a violation of our bylaw. That is a violation of the open meeting law, because that is a deliberation. Does everybody see the difference? One is a statement of fact. There is a pile of sticks. This is a real example, of course, which is why I think it's funny, but I know you probably don't. There's a pile of sticks, not a violation. What that pile of sticks means is a discussion about what that means is a deliberation. So yes, we see the pile of sticks. Thank you. As compared to saying, see that pile of sticks? That's in the buffer zone, which is, not allowed. They aren't allowed to cut in the buffer zone. And in my view, that's a violation of the wetlands bylaw. It's sharing my feelings, ideas, beliefs, and concerns about a matter within in this case, the Conservation Commission's jurisdiction. So what can you do? Well, if you have a talker on your board or committee, we all know people who do, then you may want to not have everyone attend the same site visit. Maybe a couple of people go to one and a couple of people go to another, which avoids a quorum being present. And therefore, even if someone talks about the meaning of sticks, it won't violate the open meeting law. So that's one option. The other option is, or you can do this as well, is to post a meeting for right after the site visit. So a properly posted meeting in an accessible location where the public has notice and can attend. And then when you get there, to say, remember I pointed out that pile of sticks? Well, I want to talk about what that means now. I think that's a violation, and here's why. So essentially, you give an opportunity to deliberate over what you've seen immediately following the site visit. Okay. The other thing that does not constitute a quote unquote meeting for purposes of the open meeting law is if one board goes to a meeting of another board, provided that that other board's meeting is properly posted. So let's just use an example of the select board going to a planning board meeting. The select board can go to a meeting of the planning board, even if all of them go, and even if they all decide that they're going to go, like they talk about it at a meeting, we're all going to go to this planning board meeting. That does not violate the open meeting law. That the select board doesn't need to post. And as long as they don't deliberate, there's no open meeting law issue for them. However, again, and not this select board, of course, but if there's people on the select board that are going to talk to each other and you're the staff, you wouldn't let it go like that. You'd want to post a meeting for that board so that if there was a deliberation, and I'll explain to you how easy that is in a second, they would have been at a properly posted meeting. And so it would be okay for them to have that discussion. So a violation of the open meeting law by a board attending another board's meeting is as simple as I get up to speak as a member of the board, I give my opinion, et cetera. And then I say, and really the whole board agrees that this is a huge issue, right? And that kind of bringing in of another member of the board while I'm sharing my feelings, ideas, beliefs, and concerns is a violation of the open meeting law because it's a deliberation unless that meeting is posted. So what are some things that you can do if the board doesn't want to post a meeting? They shouldn't sit together, shouldn't whisper, and they shouldn't drive to the meeting together. Now, is it possible that they could do all those things and not violate the law? Sure, it's possible, but it doesn't create a terrific appearance. And the risk is it's more likely that someone's going to file a complaint if they see the full board getting out of the car together or see them all sitting together in the back whispering. And obviously these are real examples. So don't drive together, don't sit together, don't whisper. And remember that a quorum is just a majority of the board. So let's say it's a 5-member board. We're really just talking about 3 people. So you really need to take care to avoid that. And then if you are going to speak, you do not turn to any of your other board members. You speak for yourself as an individual. Also, just as an aside, you can't represent the position of the board unless you've been authorized to do so. So as an individual member of a board, you're just you. Unless you've been authorized as by the board itself to represent the board. Okay. Well, I'll tell my story about, I went to a Christmas party once in a town, not this town and not a town that we represented. I got to the party and Christmas, everyone is in a great mood. And I see this like tight group of people in the kitchen. And I said to somebody like, they look like they're having a good time. And they said, oh yeah, that's the Conservation Commission. And I was like, oh, well, what are they doing? And someone's like, well, you can only guess what they're doing. Now, it turns out, according to them, that they were just talking about the wonderful desserts and deciding that the brownies were the best. This is what they testified to. But it didn't look great. And they had really controversial matters before them. So they had the right to be at that party. They had the right to talk about brownies. But it didn't look terrific. And in fact, there was an open meeting law complaint filed. So, if you start from the presumption that the only time you're going to talk to your board members about matters that are the subject of the board's jurisdiction is at a table during a meeting, you're much less likely to wind up violating the law inadvertently. Sometimes I tell that story about the Conservation Commission in the kitchen with a knife. Anybody? Yes, Clue. I'm so excited. All right. Okay. So the next thing is about the form of meeting notices. So how many of you are responsible for preparing the meeting notices for your board? Okay, not a ton. How many of you review the meeting notice before it gets posted? Okay, a few more. Bottom line is that a meeting notice under state law has to be extremely detailed. It used to be that it was sufficient to just give a general idea of what was going to be discussed. In 2011, which is when this new open meeting law came into effect, and I know I'm dating myself, the rule then was you just had to give kind of an indication of what would be discussed. And so this is a case where the AG ruled immediately after the new open meeting law. So it's the town of Freetown. And in Freetown, they had forever had an item on their agenda in the fall for quote unquote fall soil permits. And they had done so after the open meeting law changed. It was, everybody knew what it was in theory. And they acted on, 15 or 20 permits under that heading. Well, the AG said that the new law did not permit a general statement of that nature, and that for every fall soil permit that was going to be considered or acted upon, it needed to list the property owner and the address of the property. So it requires that there be specificity. So when there's going to be appointments, or there's going to be, 5 hearings on X, Y, or Z thing, all the information we know about those things, about the appointments, et cetera, should be on the meeting notice. The use of old business or new business, I think that's been around probably much longer even than I have been around. Under the new open meeting law since 2011, that is not permitted to be sufficient if the chair reasonably knew what that old business or new business was at least 48 hours prior to the meeting notice posting. So the question of what the chair knows is what the AG looks at what they reasonably would have known 48 hours prior to the time and date of the meeting. So if something comes up after that 48 hours notice, well, that's fine, and it can be added. And we'll talk about that in a second. But what the chair puts on the agenda is what's going to govern things. So if, for example, real life example, Department of Public Works Superintendent gives a weekly report at the weekly Board of Public Works meeting. And every week it says old business and new business on the agenda. Open meeting law complaint is filed, and the AG said, whatever that new business was that you knew you were going to be talking about had to be listed on the agenda. Whatever that old business was had to be listed on the agenda. Something could be brought up that the chair didn't anticipate under either of those headings, but otherwise, no. So in many towns, what they do is they'll put like a little star next to old business and new business to say, this item is for agenda items that the chair didn't reasonably know about prior to the time of posting. What can you do and what can't you do? You cannot use acronyms and abbreviations. This is especially important for land use boards, for affordable housing trusts, where there's also EOHLC and strange state agencies like that, DEP, not so strange, but still has to be spelled out. The quote unquote home program, which is a housing program, it's an acronym. All things like that have to actually be spelled out and not abbreviated. The meeting notice has to include the time and date of posting, and your town clerk's office does a wonderful job at this. It also has to include, if that meeting notice is revised, the time and date that it was revised, and it has to demonstrate somehow, whether it's bold or highlight or whatever it is, the thing that had been added to the agenda. Okay. So what can you talk about? And this comes up a lot before the new open meeting law. You could really talk about anything, whether it was on the agenda or not, had to be, quote unquote, reasonably related to the subject matter. That is different now. The range of things that can be discussed include the things that are on the agenda and things that the chair or the staff person supporting that board wouldn't reasonably have known about prior to the meeting. So if you have a public speak or a public participation portion of your meeting and someone brings something up, the board isn't prohibited from talking about it or from voting on it. The AG recommends that that be pushed forward to a meeting where it can appear on the meeting notice for several reasons. One, other people might be interested in it and didn't have the opportunity to know that it was going to be discussed. From a kind of board procedures perspective, the board didn't have any time to prepare to discuss it. And so it might be better if it's pushed forward, but the board can talk about it if the board chooses to. What else? And again, yes, go ahead. Yes, they can talk about it and they can vote on it. Again, whether that's a good idea is a different question. And sometimes, it could be something that cannot admit of delay. And the AG recognizes under those circumstances that, yeah, you need to vote. An example of this is a town that was the recipient of a federal grant for bike trails. And in order to continue to qualify for the grant, they had to vote to appoint a bike committee no later than, let's just say, October 31st. I can't remember the exact date. And in the middle of August, the chairperson was away, and the staff person opened up the mail, and it said, because back then we got notified of things by mail. It said, if you don't give us your bike committee names by the next day, you will not be able, this grant will be withdrawn. And the staff person tried to contact the chair, couldn't reach the chair, couldn't figure out whether to update the meeting notice. This was right after the change in 2011. Eventually the chair, who was on a plane, landed. The person contacted them, and they updated the meeting notice about an hour before the meeting was held. The chair raised this issue at the meeting. They took the vote and appointed the bike committee. And of course, an open meeting law complaint was filed, and the AG said, yeah, that was totally fine. They had no reason to know that this was going to come up, and they literally found out the day of the meeting, and they updated the meeting notice as soon as they were able to. So there was no violation. So yes, it can be brought up if it was something that the chair didn't reasonably anticipate, and it can be voted on. And whether to do so is a policy decision. Okay. A reminder that, yes, go ahead. That's a really good question. So in that instance, would you have to reaffirm the vote at the next meeting? And because the answer is coming from a lawyer, the answer is it depends. If it's really something like that I just described, then really you don't have to ratify, validate, and confirm at the next meeting. It wasn't improperly acted on. The board discussed it, the board voted, they were at a properly posted meeting, and that's good enough for purposes of the open meeting law. If there was, some question, for example, about whether the chair really could have reasonably anticipated it, and the board is concerned that someone might file an open meeting law complaint, the board can on its own choose to include it on an agenda at a future meeting and have a full and fair discussion of the issue on the merits, and then revote it. And that would, if there had been the potential for an open meeting law violation, that would cure it. It cures an unintentional violation of the open meeting law. So sometimes we'll see this with maybe there were some emails between members that kind of come to light after the vote was taken, but before a complaint is filed, and the board will, on its own initiative, without a complaint being filed, put the same issue back on the agenda at the upcoming meeting for the purpose of curing that unintentional violation, have a full and fair discussion of the issue on the merits. It doesn't cure a violation or a potential violation if the board just says, we took this vote, we're going to revote it. That's not a full and fair discussion of the issue on the merits. Okay. So if the matter arose after the 48 hours and it's legitimately something the chair couldn't have anticipated, and the board votes on something, that is fine. That is consistent with the open meeting law. If there's a concern that there was a violation, or there's a fear that someone might file a complaint or whatever it might be, nothing prevents the board from taking that further action at a future meeting to ratify, validate, and confirm. Okay. Oops, let's go back. Sorry, Maureen. You cannot continue a meeting from one night to the next unless the meeting is posted for that next night. So especially for land use boards with public hearings or any other board that has a really long agenda, if there is a concern that it's going to need to be continued to the next night, that next night meeting has to also be posted. If it's not posted, then continuance of the meeting has to be to a time at least 48 weekday hours after that meeting can be posted. So we can't even go from, tonight to Friday night. because that's not 48 hours after the meeting is posted. It's 48 hours after this other meeting. So again, it's fine to post for both nights and cancel the second one if you don't need it. It's not fine, and I'm sure this isn't a surprise, to post like a meeting for every night of the week. And, then just cancel the ones that you deem to be convenient. It isn't a kind of gotcha thing. It's not a whack-a-mole type of situation. But if you legitimately think that the meeting could take 2 nights, then you can post for 2 nights. Okay. The other thing is that a lot of times at public meetings, you're there for more than one purpose, right? You're there under the open meeting law to have a discussion about issues X, Y, and Z, but you may also be there to hold a public hearing on a matter that the board has to act on in a quasi adjudicatory manner. So for example, we'll use the Zoning Board of Appeals. They might be meeting to talk about new zoning bylaws, but they may also have, an application for a variance before them. And under state law, if they're going to have that public hearing on the application for a variance, other types of notice is also required, or other types are also required. We have to give notice to abutters, we have to publish in a newspaper, et cetera. The notice provided for the open meeting law is only for the open meeting law. So in my example, if the other types of notice that's required for a zoning bylaw amendment, a variance application, are not provided, then they can't meet to decide on that variance application. They're at a legitimate, properly posted public meeting, an open meeting, but they haven't complied with the notice requirements for the other statute that's applicable. One does not substitute for the other. Same thing, if they'd done all of the meeting notices that went to abutters and published in the newspaper and did all of that, but hadn't posted under the open meeting law, they can't legitimately hold their public hearing. So you need both, okay? All right, emergencies. So the Attorney General's office doesn't really believe in emergencies for good reason. They think that if you fail to act on something and tomorrow is the deadline, that's an emergency of your own creation, and they don't typically find that to be a compelling type of emergency. But as we know from the past few years, there can be public health emergencies, there can be public safety emergencies. I don't know how many of you remember the April 1st where there was elections canceled all over the state because there were snowstorms. That is an emergency. Water coming over a seawall that makes a road impassable, that is an emergency. And under those cases, or in those cases, what a board can meet to the extent that it needs to deal with that emergency, and it needs to try to comply with the open meeting law to the extent it can. So post as soon as they know, take minutes, post a link if it's going to be a remote meeting. This whole kind of theory started back before there was such a thing as remote meetings. And the idea was probably that, the select board might get on the phone and try to resolve a public safety emergency in a quick way. Now we have remote meetings. You have to try and comply to the extent that you can. So post, make a Zoom link available if possible, take minutes. That may be the kind of thing where you do intentionally post 2 meetings when you post the emergency meeting. You post the emergency and a properly posted meeting with the 48 weekday hours notice so that you can go to that second meeting, ratify, validate, and confirm the action that you took at the first meeting, explain why it happened the way it did, and what the board discussed. Okay. Recording of meetings. So under state law, any person can record an open meeting provided that they give notice to the chair that they're going to do so. In addition, meetings that are recorded by the local cable television, also the chair would need to announce that. There is such a thing as a state wiretap law, and essentially says you can't make audio recordings without permission, 2-party consent. As a chair, you can say what the rule is. You need to tell me if you're going to be recording. Is anyone recording? But that's really how far that goes. It used to be that it was disruptive when people wanted to record. They would like come up to people's faces with a microphone, with a tape recorder, or for those of you that remember, the why am I not remembering the word? Video cameras, where people would like carry these huge things on their shoulders, and they would like come down and try to get good angles. And under state law, the chair can say, you can stand over there. You may not go walk back and forth in front of people, but they have the right to record. Okay. All right. Any questions up to now? All right. This is the part where sometimes I get tomatoes thrown at me or really mean things said to me. Under the open meeting law and the public records law, email is a very dangerous thing. For those of you who are town employees, you already know that any email that you send, anything that you put in writing, is subject to mandatory disclosure upon request. That same rule applies to volunteers. And so anything that you do in your capacity as a town employee or a town official, anything that you write or send, or anything that you may receive, whether it's a text message or an email or an old-fashioned letter, is a public record subject to mandatory disclosure upon request. The additional complication for boards is that an email or series of emails can create violations of the open meeting law as well. So one way that we see violations is, I'll just use a real life example, which is a very unhappy resident emails a full board saying, you all made a terrible decision. Here's all the reasons why, this person was had a self-interest, and this person hates this, and, very antagonizing and confrontational. And one of the board members writes back and says, this is outrageous. In my opinion, we rested our decision on the facts. And that person is sharing their feelings, ideas, beliefs, and concerns amongst a quorum of members, and they have just violated the open meeting law. Okay. Another way that happens is, let's say you're a staff person and you send out an email to all of your members, and it has, some analysis that you've done, or it's forwarding some information, or it's even saying, hey, we need to get the agenda together for next week. Send me your input. And someone replies to all and says, it is my top priority this year that we blah, blah, blah. Violation of the open meeting law, because that person is sharing their feelings, ideas, beliefs, and concerns. Someone writes back to the staff person and says, I totally disagree with the way that you framed this, and I think you needed to blah, blah, blah. Violation of the open meeting law, sharing feelings, ideas, beliefs, and concerns amongst a quorum. It is that easy. It is also that easy. Let's say Maureen and I are on a board together. I send my thoughts on something to Maureen. Not an automatic violation of the open meeting law, assuming that we have 5 members on our board. Maureen thinks it would be good, for you to know what I was thinking and what she's thinking, and forwards that email, even if she doesn't say what her opinion is. Now, my feelings, ideas, beliefs, and concerns have been shared amongst a quorum, and that's a violation of the open meeting law. The other thing is, you don't get to control where your email goes after you press send, whether you're a staff person or a board member, and anybody can forward that to anybody else. And so let's just say this was something between me and Maureen. Maureen sends it to a friend who's not on the board, and the board member thinks, you should know about it, and forwards it. Now that's also a violation of the open meeting law, even though it's really no one's fault per se. The AG doesn't care how it winds up. They don't care if the person in the email intentionally, in the first email, the confrontational one, wants to kind of get a response for the purpose of creating an open meeting law violation. They don't care if it's an accident. They just don't care. In fact, if I send an email to the full board sharing my feelings, ideas, beliefs, and concerns, and everyone else is like, I am not responding to that because that would be an open meeting law violation, it's still an open meeting law violation, even if there's no response. So what does this tell us? there is a very high level of risk using email to talk about town business if you're a board member. And board members really should limit, and I know this is not realistic because we live in the year 2024 and we all use email in our private lives and in our public lives. But you should limit your use of email with respect, if you're a board member, to your town business, except for scheduling purposes. You could share something that someone else wrote about a particular topic. So if there's a story in a newspaper or something like that, you can share it with the other members of the board. It's not your feelings, ideas, beliefs, and concerns, as long as you don't say they hit the nail on the head. As soon as you say that, now you've shared your feelings, ideas, beliefs, and concerns. So number one rule, do not seek or provide your opinion on anything if you're a board member. Do not reply to all. In all of my examples, if the individual at issue, instead of replying to all, had simply replied to the individual who had written the email first, it wouldn't necessarily create an open meeting law violation. So let's take the first one with the confrontational email. If an individual member of the board simply writes back to that individual and doesn't copy the other board members, now no open meeting law violation has occurred. Yes. So the question is, could that individual forward your response to the full board and create an open meeting law violation? Yes. There is always going to be a risk in sharing your feelings, ideas, beliefs, and concerns with others if you're a board member by email. Yes. Hypothetically, right? Okay, yeah. Having a full and fair discussion of the issues on the merits at a properly posted meeting and making that recipe part of the minutes of the new meeting. Yeah. Whenever, I mean, and again, it's one thing if I am a board member and I'm kind of diabolical and I'm like, I'm going to send everyone my opinions and open meeting law, whatever, I don't care. That is potentially going to be viewed as an intentional violation, or at least there'll be consideration of that from the Attorney General. That's different than inadvertently acknowledging, okay, this probably violated the open meeting law, or, oh gosh, when that got forwarded to so-and-so, I didn't realize it was going to violate the open meeting law. Inadvertent or unintentional violations of the open meeting law can be corrected by a full and fair discussion of the issues on the merits at a properly posted meeting, and taking whatever that open meeting law violation was, whether it's an exchange of emails or text messages or, whatever it might be, and making that part of the minutes of the next meeting. That's how you cure an unintentional violation. Any other questions about email? So do not press reply to all. Just don't do it. Okay. If you're going to put something in writing, and this is as much from a public records perspective as any other, think about, is that something that needs to be in writing? Do you need to put that in writing? And I say that not because I'm paranoid, although I have good reason to be based on what I've seen, working with cities and towns for a really long time about what can happen, but also because, as I'm sure many of you have said to your children or teenagers, anything you put out there in this digital world is there forever, and it may pop up in places and times that you do not want to see it. So be thoughtful. I always mention it could be the 1 hour rule, but I like to refer to it as the 24-hour rule, which is if you are extremely pleased about something or extremely upset about something, do not press send on the email that you just wrote in the heat of passion. Give it a little time and go back and make sure that that's, what you're comfortable with. And especially in the social media world, public employees and public officials, once that's out there, it's really hard to take back. In our private lives, we can walk certain things back, but when that's out there as kind of your statement on something, it has a different weight than it would if you were doing that in your private capacity. Okay. So, those are the things. Email and text messaging and social media are all subject to the same types of pitfalls. The open meeting law specifically addresses email, but the supervisor of public records has and the attorney general have found that text messages and social media posts can create the same violations. If you are a staff person responsible for a town webpage, that's a public record and you need to know how to save what is posted there. If you post on social media and you're a board member, you need to be thoughtful about whether others from your board have also posted on that chain. What's the best way to approach it? Don't post. What's the worst? Just to jump right in with your feelings, ideas, beliefs, and concerns, and to tag your other board members in that post. If you tag the other board members, it will be deemed to be an open meeting law violation. If 2 people of 5 have commented on a post, not technically a violation of the open meeting law, as long as no one was targeted, meaning at whatever. But if that third person jumps in with their feelings, ideas, beliefs, and concerns, now that is an open meeting law violation. How can you avoid that if you're a public official, especially if you're elected? It's like people elected you because of what you think about things. To say, this is a really important issue under the open meeting law. I cannot share my feelings, ideas, beliefs, or concerns about this. Please come to our meeting on Tuesday to hear more about this issue. Something like that. It shows you're engaged, but it's not sharing your feelings, ideas, beliefs, and concerns. So do not direct your comments to any other member. If the matter, let's take affordable housing because that's a frequent one. If, let's say it's an affordable housing issue and you feel really strongly about affordable housing, but you have a matter pending before you that involves affordable housing, you should not jump into the fray under those circumstances, not just because of the open meeting law, but also because of the risk that you're going to create a due process problem, a due process violation. Because when you are acting in a quasi-adjudicatory capacity, what you're supposed to be doing is basing your decision on the evidence that's in the record, the information in the record. And even if you have a particular, set of values that you think is gonna, or that someone might think might tend to show you might decide one way or another, you still have an obligation to base your decision on what's in the record. And so if you're taking a position on something ahead of time, you can see that someone could say, there was bias in that decision. It wasn't based on the record. It was arbitrary. It was capricious. It was an abuse of discretion. It was a violation of my due process rights. And for those of you that work with land use boards and have seen the lawsuits that are filed, they almost always include open meeting, public records, and conflict of interest law counts, because it is one of the ways you can overturn a decision based on process issues. And although obviously a judge has obligations that far exceed whether they think the people that are making the decisions are good people or not, I can tell you from experience that when a judge is looking at a complaint and it has a bunch of counts of, I'm just going to put in quotes, like bad behavior by municipal officials, even if it's not true, that's a hurdle that we need to get past in order to support a decision. And in some places or in some instances, it can really make it difficult for a board to be successful. One of my true life experiences with that is a board that was very divided. And they spent a lot of their time at board meetings yelling at each other and using inappropriate words and, storming out and making threats. And all of that was recorded in the minutes. And basically, I forget the judge's exact wording, but he was like, this seems to be a very unpleasant situation. And you can imagine that to win in that circumstance, to win that case, to uphold the board's decision was a lot harder, knowing that it kind of looked like everyone was acting inappropriately all the time. So that is something to bear in mind in terms of, you know, when you are going to take a position on something, whether it's on social media or not, you want to make sure that it's not going to implicate or impact a pending matter before your board. The other thing is there's a recent case. Sorry, I'm just going to do one quick thing. All right, we're doing okay. There's a new case that basically said that a city manager who had used their private email address, private Facebook page, both before and after they were appointed as city manager, had made his page a quote unquote public forum. And a public forum is a place where you can expect that there will be exchanges of ideas, and where once you've opened that public forum, it's very difficult to limit what can be posted there. And this, you know, may remind you, you probably heard about the lawsuit involving President Trump from some time ago, where he blocked certain people from his, I think it was his Twitter account at the time. And the court said, you can't do that. You've basically invited the entire public to say whatever they like. And just because you don't like what this one person is saying doesn't mean that you can block them. It's a violation of their First Amendment rights. So the city manager in this case that I'm talking about had a similar situation. He tried to block someone and the court said, no, you made your private Facebook page a public forum by posting as much as you did about the city's initiatives and things going on in the city. So be thoughtful about how you use your own private pages. Yes. I'm sorry, tell it to me one more time. Hypothetically. If we're going to interview each member separately, but then create a video of the member saying, like, this member does that, would that be? Okay. So the question is, if you were going to be doing kind of a social media campaign where you're raising awareness about the board and about the members, would it be a violation to have each of the members kind of talk about what the board does separately and then put it all together in a single video? Because I can't help myself, I have to say it depends. I mean, I think it's probably fine for each board member to say, this is what, you know, this board does. They're not deliberating about a matter within their jurisdiction. They're not making decisions. They're just kind of talking about what it is that they do. But if you have concerns about that, then my recommendation would be that you play the video for the board members at a board meeting and make sure that they're comfortable with what's, you know, being shared. And then once they're comfortable with it, it's essentially a video of the boards and they've, you know, they've deliberated about it, properly posted, open meeting. I don't see that any complaint could be brought at that point. Okay, so the next part of what we're going to discuss is related to the Barron v. Calenda case. And that case, for people that don't know, is about the Southborough civility policy that the select board had there. Has anybody heard about this? It was in the newspapers and, you know, I don't know if it caught your attention, but basically what it said is, if it's back to this public forum thing, if you've invited the public to speak at a public meeting and you haven't limited the topics or the content or the length of time or anything like that, then everybody has essentially a right to speak their mind. They have a right to petition government. And so you can't treat somebody whose speech you like differently than somebody whose speech you don't. And in this case, and it was a pretty ugly scenario, there were people sitting in the back of the room holding up signs that were saying, this is the select board, you're criminals, like you've stolen money, you've done this, you've done that. Obviously not a comfortable position for the board. So they're in the back, there's a public participation period. They had this civility policy. One of the people in the back, Barron was the woman's last name. She comes up and she basically starts yelling at the board and giving them, you know, making accusations, et cetera. And the chair, you know, was uncomfortable. You can see it on the video. Like, what's, you know, a chair supposed to do? This is out of control. And so at some point the chair was like, that's enough. And She didn't stop talking and he took a recess, and you can see him yelling at her. You can't hear the video, hear the audio, but you can see him yelling at her like to get out and swear words. And the court basically said that was a violation, or the court said that could have been a violation of her civil rights, that of her right to petition government, and that where the board had invited anyone to speak, they really didn't have the ability, or it didn't have the ability to differentiate between speech they liked and didn't like. And so that created a huge change with respect to the law and the conduct of public meetings. Interestingly, for those of you who find these things interesting, obviously I do, the decision doesn't mention the open meeting law at all, which seemed like a pretty big omission, because under the open meeting law, the chair has authority to control the meeting. The chair is the only one who is authorized to speak, and the chair is the only one who is authorized to represent other people to speak. And the entire proceedings are under the direction of the chair. And that didn't change because of the Barron case. So let's go to the next slide. You can't read this, and I can't either. But this is essentially a summary of the case that I just spoke to you about, Barron v. Calenda. So we can go to the next one. There was another case a few years back about the town of Natick, and so that's the references there as well. Similar thing, you can't limit the public's comments during a public comment period. Okay, let's go to the next. So there's a few things for a chair to think about, and the first is, is there going to be a public comment period? If there's not a requirement in a charter, there is nothing in the open meeting law that gives any person the right to make comments to the board at a meeting, to a board at a meeting. Not with respect to things on the agenda, not with respect to things off the agenda, not in the middle of deliberations, not before, not after. The open meeting law does not give anyone that right. So whether to have a public participation period is a policy decision, and then how to manage that is also a policy or a series of policy decisions. First is, are you going to have the public participation period at the beginning or the end of the meeting? The benefits to having it at the beginning is that you hear what people have to say and it's done. The benefits to having it at the end is, if the people at the beginning hate all the things that are on your agenda and say things that are negative and awful, the meeting hasn't been hijacked by that discussion, and instead, it comes at the end. The downside of that is everybody who leaves the meeting remembers those were the things that were said. And not all public participation obviously is negative. It's just that it can be. How long is it going to last? So in order to put reasonable time, place, and manner restrictions on the on the public speech, they have to be content neutral. So reasonable time, place, and manner restrictions means not with respect to the content of speech. It has nothing to do with about anything that people are saying. And it has to do with content neutral decision making. So we might have a public participation period of 15 minutes. We might allow every speaker who's going to speak 3 minutes, unless there's more than 5 speakers, in which case we might say it's 2 minutes. We might decide, or the chair might decide, we're going to let people speak twice if there's time and everyone else has spoken, or we might say, no, there's no ability to speak twice. Yes.
Otherwise, that would be a violation of the open meeting law on a topic. They're deliberating on something that isn't posted.
So the question is, if it comes up during public participation, can the board kind of get into a discussion about it? Would that violate the open meeting law? And the answer is, it depends. If it's something that the chair would have reasonably anticipated, then yeah, the board can't talk about it at that meeting because the chair didn't put it on the agenda. If it's not something the chair reasonably anticipated, the board is not prohibited from talking about it. Whether it's a good idea is another thing, and we'll talk about that in 1 second. Another thing that's not up here is the idea of whether a person who's been recognized to speak can cede their time to another person. And the answer to that is only if the board chair, or the policy allows it. Because remember, the chair is the person that determines when someone's going to speak. So an individual who's been recognized to speak doesn't all of a sudden have more authority than the chair with respect to that. Yes. You really want me to say it depends again. The question is the decision made in advance? Can it change from topic to topic? And the answer to that is it can change from topic to topic. If you asked me whether it could be made on the spot, I would say I would prefer that you did not. I prefer that it was made in advance, because again, it's probably more likely that if it's in the moment, and again, not intentionally, but just human nature, that you're more inclined to allow someone who's saying things that you agree with to speak longer than to allow someone who you don't agree with to speak longer, to allow someone who's being polite to speak longer than to allow someone who's being rude or perceived as being rude to speak longer. So making those decisions in advance protects the town and the chair from the assertion or the assumption that the person is making decisions based on the content of speech rather than on these content neutral time, place, and manner regulations. Yes.
Let's say the town code have different policies on public participation, or must it all fall under one policy of town government?
Let's go to the next slide, I think. No, I'm going to answer. Okay, so I have been asked this question in many places, not here. And in some of those places, the select board, and this is towns, the select board has really wanted to adopt a policy that applies to all board and committee meetings. And I have said, I think there's authority for that, because this directly relates to potential liability for the town for violating civil rights. There is the potential that we'll pay attorney's fees and triple damages. That's very significant, because there could potentially, and I don't want to scare anyone, be liability for individuals, because although indemnification is something that is provided for by law for public officials, it is not available in the event of a civil rights violation. So if a select board chooses to adopt a policy and say all boards and committees are going to comply with this, in my view, because it relates to liability, a board can do that. In some of the towns that I've worked with on these types of policies, the board isn't interested in that. They don't want to. They want every board to figure it out for themselves. And I think that's fine too. So it really depends on the town. The risk is, of course, if there isn't a policy that everyone is following, that the way you implement your policy or you implement your policy isn't exactly compliant with the First Amendment or the other references in the state constitution that protect speech. And so, a person, and believe me, this is a lot for boards and committees to learn. It's a lot for individual chairs to deal with, because in the heat of the moment at meetings, it really is hard to stick to a particular script. You don't want to cut someone off at the end of 3 minutes because it looks rude to do that. And yet, if you don't cut off that person, then and you then cut off the next person who's saying something that is perceived as negative, that person's going to say, you let that other person speak for 4.5 minutes, but then you limited me to 3. That's a violation of my civil rights. And could they prove that? I don't know, but maybe. So I do think that there's value in having a policy that everyone understands and follows. And whether that has to be one that's applicable to the whole town or just to ensure that each person that's chairing a committee understands how significant this issue is. And I have seen chairs kind of grow into the role, because at the beginning they are uncomfortable saying you have to stop talking. And, 6 months later, they're like, hey, those are the rules. Like, I make it clear at the beginning of every single meeting, I'm going to cut you off at 3 minutes. When you hear my iPhone alarm, you're done. And I don't care if you're in the middle of a sentence, that's what it's going to be. So sometimes it does take a little time. Now, the question about do the same rules have to apply for all parts of the meeting? And the answer to that is no, a policy can have different rules. So for example, the beginning, there might be a public participation period at the beginning of a meeting. I'm not making this up. This is in someone's policy. That really relates to anything within the board's jurisdiction. They're allowed to come in and talk about anything. And this is a select board. So there, there's a significant amount of subject matter that's within the board's jurisdiction, but they have limited public speak after or before certain other items on the agenda. So under those items, it might be, we're just going to talk about this thing that's going to be, that the board is going to talk about in substance. We're not going to talk about all the things within the board's jurisdiction, just this thing. And I've also seen circumstances where there is a public hearing about something on the agenda, and during public speak, someone gets up and wants to talk about that. And the board chair will say, we're happy to hear you during the public participation period, the public hearing part of the meeting at, under agenda item, whatever. So there can be different rules, but those different rules have to be implemented on a content neutral basis. Yes.
Say you are regulatory authority, the hypothetical grounding, and you are not under legislation or special act required to actually conduct quote unquote public hearings, either in any form or fashion in the legislation or the requirement to make a public notice of it. And you determine that you would like to have, what I understand, specific limitation with the chair. The chair can also determine whether anyone speaks or not, because that's the public meeting, not public hearing.
Yes.
And particular item that's being reviewed, say you've got 50 on your agenda.
I'm sorry.
Yeah. The chair, whomever it is, and probably with deference of policy to the board in a separate prior notice meeting, having discussion policy, can determine if people speak, to what extent they speak, and if they're not on a topic where they're abusing the process, they can be shut down without, I'm going to say but without this fear of violating someone's First Amendment right. It is very specific.
Yeah. Okay. So the question is essentially, if there is a matter where there's no public hearing required, I mean, from my perspective, there could be a public hearing requirement. And the person who is speaking about this particular subject matter all of a sudden starts talking about something else, or winds up somehow abusing the process, speaking over someone else, not stopping talking when the board chair says their time is up, whispering in the audience, which you guys haven't done. Thank you very much. And other things that are disruptive to the conduct of the meeting. Yes, that kind of behavior can be shut down. It is disruptive. It is not a First Amendment issue. The content of the speech, and this is why I was saying there could be a difference between a general public policy public participation period, and a public participation period on a particular item. If it's on a particular item and the person starts talking about something that happened 20 years ago, that's irrelevant to this current thing, the chair can say, we're actually not talking about anything but blah, blah, blah. Please bring your comments back to that. Otherwise, I'm going to ask you to sit down. And the chair, under the open meeting law, you give one warning, you give a second warning, and in theory, you can have someone be removed from a meeting if they do not comply with your order to sit down and not keep speaking. Obviously, that's kind of a worst case scenario. The more you're able as a chair to control the meeting and keep that kind of behavior to a minimum, the better. A lot of the policies have a list of the types of behavior that is seen as disruptive and that would result in a person being told that they need to be quiet or they need to leave. So yes, First Amendment rights are not implicated every single time a chair tries to control a meeting. Yes.
That matters outside of the hypothetical making committee's regulatory authority. with the concept being that they're bringing up matters that if Brown may be considered could be grounds for, an appeal or a reversal of the decision, that also is not something individual speaking is protected.
So I mean, it's hard for me to it's a little bit hard for me to follow because of our brownie making committee is, I don't know what their jurisdiction is. But, I would say that the better or the more able you are to stay away from shutting someone down because of the content of their speech, the better off you are in terms of avoiding an open meeting law by avoiding a potential, civil rights violation. So for example, if everyone has 2 minutes to speak and someone starts talking about something that they think should influence X, Y, and Z, but it's 2 minutes, then, they don't have the time to really get too far into that. And the 2 minutes are over and the chair can move to the next person. One of the things that I have up here, as issues to avoid is to avoid debate, to avoid getting into an interaction with a public speaker, because it doesn't impact what the board is ultimately going to be discussing. It's the board's meeting, it's the board's deliberation. And yes, someone can have a perspective that may be useful, someone could have a perspective that might not be useful, but ultimately it's the board that is going to be discussing the issues at hand and the board that's going to be making a decision. I also asked, if you're a board member, that you consider kind of the context in which some of these things come up. A lot of times they come up, the board has no idea what this thing is. It wasn't on the agenda. They don't know. They may not have ever talked about it. So it's better to avoid having somebody kind of jump into the fray to talk about this thing when they have no idea how their fellow board members think, or if this is something even that's appropriate for their discussion. So that's another one. This is a tough one, leaving matters unresolved. I think we're all pretty used to trying to solve problems. And so when someone raises something during a public participation period, we want to rush to explain or work it out or fix it. And it's fine to say, thank you for your input and leave it at that. And if it's something that can be fixed later, maybe you direct the staff person to deal with it at the meeting, or maybe you don't, and the staff person comes to you with an idea about whether or how to continue to look at it. And then finally, if something is of interest to the group and, but the chair deems it's not appropriate for discussion at that time, for many reasons, including that the board may have a 50, item agenda and have a lot of its own work to do, that the chair can either right then or in the future say, I'm going to put that on a future agenda. But this idea of not getting into a back and forth really makes a huge difference in terms of meeting conduct, in terms of the way the meeting goes. And it also reduces the chance that somebody who is disruptive is I'm putting it in quotes, disruptive, who is speaking negatively about the matter or about the board or about board members even, is going to be able to kind of hijack that discussion away from what the board really needs to be doing that day. So those are policy things to keep in mind, but I will say that meetings where those set of rules are followed are typically they're typically kind of well-oiled machine as compared to a kind of chaotic event. Yes, I saw your hand several times.
However, what if you have somebody in the public who will not relinquish the mic? You don't have a sergeant at arms for a small commission. You don't have a police presence, nor would you really want that or need that. Can you call a recess of the meeting?
Yeah. So the question is, if you have someone that won't follow the rules, isn't, at the end of their 3 minutes, you've said your 3 minutes are up, you need to stop speaking, please sit down, you've done the 2 warnings. You don't have someone there that can remove the person from the meeting. Is it appropriate to call a recess? And I think the answer to that is yes. I feel it is important for you to have followed the protocol up to that point, meaning you cut everyone else off at 3 minutes and you gave the person the warnings that the open meeting law requires, which is one, just general warning, your time is up. Another, I've already asked you to stop speaking, please stop. The third one, if you don't sit down, I'm going to have to take some further action. Yes, I think it's appropriate under those circumstances to take a short recess. Please don't yell at that person on the video, like in the Barron case. And sometimes a chair under those circumstances will be like, that's it, I've had it. I'm asking for a motion to adjourn. And that's also okay. You don't have to get into it with an individual. And the chair runs the meeting. And if the chair feels that the chair is unable to control the meeting for whatever reason, then the chair has the ability to ask for a recess or to ask for a motion to adjourn. Okay, so we're very behind schedule, but you're all still here. So should I assume that means we should just keep going? No one is standing. Well, he's standing. All right. Yeah. Probably 10 minutes. And it's not rude, I promise. Okay, minutes. For those of you that do keep minutes, or if you're a board member, know that your draft of the minutes is a public record from the moment of its creation. So literally anyone can walk up to you at the end of the meeting and say, please provide me with a copy of your minutes. So you don't want to use your minutes to write notes to your neighbor, and you don't want to write things down, real stories like, oh, I love her jacket, or is she serious, or that hair. Those are things, no one, not a laugh, not a smile, this group. So you really want to be thoughtful about what you put in your minutes. If you are not the person taking the minutes and you do not share your notes with anyone else, then they are subject to withholding under the public records law. They're your personal notes. You cannot take your notes at a public meeting and show them to the person next to you and expect to be able to withhold them if there's a public records request. Okay. Personal notes. So the notes have to be, the minutes have to be detailed. They have to include substantive discussions or substantive summaries of what was discussed, not just we discussed the open meeting law, but we discussed X, Y, and Z aspects of the open meeting law. So-and-so asked this question, this was the answer, blah, blah, blah. Not a transcript, but not just we discussed the open meeting law. If you use documents at meetings, then those documents do not have to become part of the minutes, but they do have to be included in a list of documents that are part of the minutes, that list, and they have to be made available, relatively easily for a period of 6 months after the fact. Okay. Approval, they have to be approved by a board either in the next 3 meetings or 30 days, whichever is longer. So if a board meets twice a year, then they have to approve them at each meeting. They approve the minutes of the last one. If a board meets every week, they're going to have to be approving minutes in a faster time period. Executive session, which is when a board can meet in a closed session or private session, only allowed in very certain circumstances. There's a process for entering into executive session. There's more information available about the process if you have questions. Just like when you have a remote meeting, all the votes have to be taken by a roll call vote, and the board has to vote to go into executive session by a roll call vote. The meeting notice has to include as much information about the executive session as is appropriate without undoing the purpose of the session. We'll go the same. More. Okay, enforcement. And I hope many of you don't know a lot about this, but essentially any resident can file, or not a resident, any person can file an open meeting law complaint. They file it on the form that was created by the Attorney General, and that form has to be sent to the chair of the committee. It is then the committee has 14 business days to meet, talk about it, and decide how it wants to respond. At the end of the 14th business day, the town's response along with the complaint is sent to the Attorney General. The individual who's made the complaint has up to 30 days after, can file after 30 days has elapsed since the complaint was filed. The AG has a huge range of options in terms of how they want to handle it. If they handle it with a letter determination, the town has 21 days to file a complaint in Superior Court challenging that decision. That is a very, very short time period. So if any board does get a negative determination that they think they might want to challenge, they have to act on that immediately. The AG can go directly to Superior Court, and 3 registered voters from the town can also go directly to Superior Court. We have this for until the end of March 2025. That is very, very soon. You'll see more reporting about this as we get closer to the date. The legislature has missed the date the last few times they've done extensions. I think it would be great if they didn't, but it's probably possible that, or probable that they will. We'll have to see what happens. Okay, so conflict of interest law, we don't have a ton of time for that, but it is exceptionally important. We have 5 minutes. So what I'm going to do is go to the next slide. Whenever I talk to municipal employees, which include volunteers, about the conflict of interest law, I talk about the red flag rule. It is not in the statute. It does not exist except in my head. And that is, if something feels uncomfortable to you, if you feel like you may have a conflict, either because of the subject matter, because of the people involved, you need to recuse yourself from the participation in that matter, unless you've consulted and done an appropriate disclosure, gotten permission or whatever it might be to participate. So if you're at a meeting and in walks, I said this yesterday, you're like random uncle, and you had no idea that they were going to be there, and you're worried that it's going to look terrible, and you say, I don't want to be involved in this. It's going to make me look bad. It's going to make the board look bad. You can recuse yourself, which is to stand up from the table or in your official position and go and sit in the audience, or just if you're in an official position, not a board member, to just absolutely not participate. It doesn't mean assigning it to someone else. It doesn't mean sitting at the table while the rest of the board talks about it and abstaining. That is considered participation for the State Ethics Commission. The State Ethics Commission is an enforcing authority. If you call them and you say, yesterday, I blah, 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 they will literally say, hold please, and bring you over or transfer you to the enforcement division, okay? You never want to do that unless you are intentionally choosing to do that. You can call the State Ethics Commission, they have an attorney of the day, and ask about future issues. And if you do so, you want to make sure that you're giving them all of the relevant information. They will stand by their decision, whatever it is that they told you, this is what you should do, you don't have a conflict, whatever it is, but only based on the facts that they have. If you've withheld facts, whether intentionally or unintentionally, that are relevant to their decision-making, then you will not be protected. So it's really important that if you choose to contact them, that you give them all the information. If you're elected and you have an actual financial interest, and that can be large or small, positive or negative, if you participate under those circumstances, you will have violated the law. You cannot fix it. Okay. If you're an appointed official and you believe you have a financial interest in a particular matter, whether you're an employee or a member of a board, you can seek approval from your appointing authority. And under those circumstances, you essentially say, here's all the things, all the reasons why I probably shouldn't participate, or why I couldn't under state law because of my financial interest or that of my spouse or either of our parents, children, brothers and sisters, or a business in which you have a financial interest. The appointing authority can say, you know what, your perspective on this is still so important that we want you to participate. You basically have to say under oath that you swear that you're going to be able to make a decision that's based on what's important to the town and not on your personal perspective. You have to ask for that ahead of time. And again, that's only if you're appointed. Okay, let's go to the next. Keep going. There's a code of conduct. Sorry, we'll go back. The code of conduct basically says if you don't have a financial interest in something, but you feel like there's going to be an appearance of a conflict, you can disclose that conflict. Again, you have to do it ahead of time. If you're appointed, you make the disclosure to your appointing authority. If you are elected, you do it in a manner that's public in nature, such as at a meeting or put it on file with the town clerk, or both. And same for appointed officials. If you're sitting at a board meeting and, you know, your best friend comes in and you think like everybody here who comes frequently would know this is my best friend and they would think I'm going to make a decision based on what's best for the town. But like someone from out of town might not know, or somebody who just moved here might not know. It's better to make a disclosure on the record. So-and-so happens to be my best friend. Obviously, I'm going to comply with the state law and regulations on this, you know, based on the facts and not based on my personal relationship. I can think of a number of jokes that I would make after that, but I don't know if, so it is never a problem to over disclose. It may be in other circumstances, but not in this one. So if you want to, you know, if you look at the agenda and you say, oh, there's 4 people here that I've done, you know, business with in the past, I'm going to just notify the appointing authority that that's the case. You've now taken care of any potential complaint that can be filed. Let's keep going, keep going. Okay, the next one's good. So, acting as an agent. If you are a regular municipal employee, and that means a person that's employed full-time, or a position that has not been designated as a special municipal employee position, then you cannot act as an agent for anyone other than the town in a matter in which the town has a direct and substantial interest. That means you can't make a telephone call. I'll use youth baseball because that's like youth baseball, youth soccer. Oftentimes the people that are kind of in charge of these leagues also are volunteers for the town. And if they're not special municipal employees, they can't volunteer, or employees of the town. They can't make a phone call on behalf of the youth sports league to the town hall. They can't sign a letter requesting a permit. They can't, do anything where they're representing this other entity with the town. A special municipal employee has much more leeway in this regard. And in specific, what that means is while they can't represent anyone other than the town in a matter that's pending before their own board, they can represent people other than the town in matters before other boards. So for example, someone who might be on the recreation committee could appear on behalf of someone else if they're a special municipal employee before the zoning board of appeals, and that would be fine. So if you're a special municipal employee, you have more leeway. I believe that most appointed boards here are special municipal employee boards, but that information should be on file with the town clerk in case you want to check. Okay. Oh, you can always represent yourself. So even if you're a member of a board, and you're not a special municipal employee, or you're a regular employee of the town and you want to go and, get a permit for something, you can represent yourself. That does not constitute acting as an agent. It's not a violation of the ethics law. We talked about that. You can have more than one paid position with the town if you are a part-time employee and that part-time employment does not interfere with the other part-time work that you're going to do. If you're a full-time municipal employee, it's harder to have another paid position with the town, although not impossible. You should talk to someone about that. If you are an unpaid board member, you can, or a paid board member, you can have any other unpaid positions with the town that you want to. Okay, so it's if you have a full-time paid position that it makes it harder to have another position with the town. There are a number of exemptions and there's a number of kind of workarounds depending on the particular facts, but know that if you, for example, are a full-time employee and you put in, for a contract with the town for some service, you need to think about how you're going to deal with that ahead of time because that could create a conflict. Let's keep going. Enforcement. So complaints that are made to the State Ethics Commission are confidential, meaning the Ethics Commission will not reveal that it has received a complaint about you. Hopefully none of you already know this. If they get a complaint and they do an investigation and they give you a letter and it says, you did not violate the law, or you did violate the law, please don't do that thing again. That is also confidential. If, however, you or someone else were to reveal that the complaint was made and you want to disclose your letter from the commission, you can do that. So it's confidential if you want it to be, the letter that you get from the State Ethics Commission. And they won't reveal that a complaint has been made unless you essentially say, I'm going to wave around my letter. It doesn't stop, as someone asked in the last group, it doesn't stop someone else from telling people that they made a complaint. Remember too, that the violations of the ethics law, except for section 23, that appearance section, are criminal in nature. So it's really not something to mess around with. If you feel like you might have a conflict, it is best to try and figure it out ahead of time. The Ethics Commission, their go-to is not to go to court with a criminal complaint. You may read about it now and again, or if you get updates from them, and they do have updates, they do sometimes resolve things with a public resolution that typically includes, it's usually for financial interest issues, someone paying something back or making a donation somewhere. But the State Ethics Commission has a terrific website, as does the AG with respect to the open meeting law. And so if you do have questions, it is a good place to start. Obviously, if you have other things that we didn't address today that you're curious about or that you feel like you need answers to, please send your questions to the town manager's office, and we will do what we can to get you a response. So thank you, everyone, for your good questions and for sticking with it. And I appreciate your time and the service that you provide to the town. Thank you.